Hi, I'm Liz Gillette here with today's money tip. We're going to talk about what a financial advisor is looking at when they're reviewing your estate planning documents. Now, I should start by saying that I am not an estate planning attorney, nor do I play one on TV. But as financial advisors, it's our job to have enough knowledge. I always say we know enough to be dangerous when it comes to making sure that a client's financial life is protected regarding their estate planning. So, of course, there's some basic things that we're going to look at. We're going to look at the formalities, right? Is this signed? Does it have a witness signature? Did it need to be notarized? Did someone forget to initial on page 3? All of those things can hold up an effective estate plan transition. We also look at the timeline of events. If we say, if Mary is married to Paul and something happens to Paul, then the money passes on to Paul's children. If something happens to Paul's children, where does it go from there? And we just kind of talk through the timeline of events with clients. We also discuss things like what is the definition of competency and incapacity as it relates to your estate planning documents, right? Do you have a springing power of attorney? How many doctors have to be able to sign off on the fact that you are no longer capable to make your own decisions? In preparation of today, I actually gathered my 5 most common things that I see on estate planning documents, or hiccups, we could say. The first one is when there's an incongruency between how the asset is titled and what the beneficiary designation says. So we often see this later in someone's life. They will say, I just wanted to make it easier. I shifted it so that my bank account is a joint with my one daughter. She's my most responsible kid. She'll make sure it gets in the right hands. Well, when we see that you have a joint asset with one child, but meanwhile, we look at your will and it says, no, you want your assets to be split evenly with all of your children. There's a bit of an inconsistency there. Next is when we have complicated relationships. Who doesn't have those? So if you have a second marriage is in the picture, maybe clients from previous partners or marriages, estranged family members. It's pretty common that I see these scenarios where someone goes through the process of a divorce and we look at their documents and say, do you realize if something happened to you today, all of your hard work and the assets that you have left over would actually be going to that ex-spouse? So that's a big one that I see relatively common. Another incongruency, I'll maybe see 2 co-owners on the deed to a house, but only one person's name on the mortgage. These are areas that we look out for to really try to streamline for the client. A first to die clause, that's my 4th example for you. The first to die clause says if you and, for example, your husband are both in an accident at the exact same time, according to the estate planning documents that you have set up, who is the first one to die in terms of how the assets transfer, right, to the remaining heirs. And lastly is not getting specific enough on tangible personal property. So if you have that grandfather's clock or a ring that you want to pass on for generations to come, leaving it vague and just saying, my children will work this out, we would strongly recommend against that. So anyway, there's my quick blurb outside on a beautiful day. I couldn't help but film out here. I hope you enjoyed hearing about some of the things that are going through a financial advisor's brain as we're looking at these estate planning documents and making sure that we can reiterate it back to the client so they have a clear understanding of what were to happen should they pass. Thank you, and I hope you have a great day.